Megan Jabori, lead course instructor at JD Advising. This video is a sample of our brand new, highly reviewed lectures that have helped countless students pass the bar exam and realize their dream of becoming lawyers. For more information, please visit jdadvising.com. You can also sign up below to get our bar exam essay guide on the highly tested topics completely free. Enjoy the video and don't forget to like and subscribe for more valuable free content.
This question says, a plaintiff sued a defendant for injuries sustained during a car accident. A few hours after the accident, a police officer interviewed both the plaintiff and defendant. During the interview, the defendant calmly told the police officer, "I can't believe I did this. I was going way too fast and just didn't see the stop sign." At trial, the plaintiff called the police officer to testify to what the defendant told him during the interview. The defendant objected, arguing the officer's testimony would be inadmissible hearsay. Will the defendant's hearsay objection be successful? Here the subject being tested is evidence. The legal issue is whether the proffered statement falls within a hearsay exception or exclusion. Notice that the call of the question specifically tells us to focus on the hearsay issue that arises from this piece of evidence. So we next need to identify the rule of law for hearsay exclusions and exceptions. If the applicable exception or exclusion does not jump out at you right away, I find it easiest to start with the exclusions, and then if none of the exclusions apply, move into the exceptions. There are 5 exclusions from hearsay. The first is verbal acts or legally operative words. The second is effect on the person who heard or read the statement. The third is circumstantial evidence of the speaker's state of mind. The fourth is prior statements of a trial witness. And the fifth is opposing party statements. Ask yourself if the proffered evidence falls into any of these categories. When doing this, I find it helpful to go back to the facts and first look at who made the statement. Here the facts state the defendant calmly told the police officer. So the defendant is the person who made the statement. Next, look at who is offering the statement into evidence. Here the plaintiff has called the police officer to testify. So the plaintiff is offering the statement of the defendant. In other words, this is a statement of the opposing party. Thus, it falls into the exclusion category of opposing party statements. Remember, anything an opposing party states can be offered against that party. Because we know opposing party statements are excluded from the definition of hearsay, we can conclude that this proffered testimony is not hearsay. So going back to the question of whether the defendant's objection will be successful, the answer must be no, because this statement is excluded from hearsay, or in other words, it is not hearsay. Now let's look at the answer choices and see which answer choice contains that answer. We know that the answer to the question is no, the objection will not be successful. So we should start with the no answer choices. Answer choice A says no because the officer's testimony is non-hearsay. This is exactly what we just concluded, that the statement is not hearsay because it falls into the exclusion for opposing party statements. So this looks like a good answer choice, but we should check the others and make sure this is the best answer and also see if we can explain why the other answer choices are incorrect. Answer choice B says no because the officer's testimony falls within the present sense impression exception. You might be tempted to pick this answer choice because the defendant is telling the police officer what just happened, so it sounds like he might be describing the event as it is happening or immediately thereafter, which is what is included in the present sense impression exception. However, present sense impressions fall into an exception to hearsay. Here we have a statement that is not even hearsay because it falls within an exclusion. So we don't need to apply an exception for this statement to be admissible. Even though this answer choice might be true, it is not the best answer. Answer choice C says yes because the officer's testimony does not fall within the excited utterance exception. This might also be a compelling answer choice, particularly because the facts state that the defendant calmly told the police officer what happened. You might think that because he spoke calmly, he was not excited. However, as we previously discussed, the defendant's hearsay objection will fail because this statement is not hearsay. So this answer choice has the wrong conclusion. We want a no answer choice instead of a yes answer. So even though the statement probably does not qualify as an excited utterance, this is not the best answer choice. Finally, answer choice D states yes because the officer's testimony contains inadmissible hearsay. This is simply not true. The statement is not hearsay because it falls within the opposing party's statement exclusion. Therefore, this answer choice is incorrect. In conclusion, the best answer choice is answer choice A. The defendant's objection will fail because the proffered statement is not hearsay.